Mr. Deakins.
I appreciate the opportunity to again appear to address the issue of issues for litigation in the pre-election hearing. The proposed rule eliminates the right of the parties to litigate employee eligibility if the group of employees affected is less than 20% of the bargaining unit. I think this is a direct violation of Section 9C of the Act, which calls for an appropriate hearing upon due notice and virtually guarantees that this rule will be contested in court. I also see a conflict in what the board is saying here. For example, in describing the reason for requiring employers to file a list of eligible voters as a part of the statement of position, the board says it does so because it is important to attempt to resolve disputes concerning eligibility rather than prolong them. Why is this important when it comes to giving the union an early list of employee names and not when it comes to actually determining employee eligibility? The most important eligibility question in most cases is the supervisory status of certain employees. If the employees are supervisors, the employer must be sure to instruct these employees on the restrictions which apply to them in the campaign, including the instruction that they may not engage in union activity. On the other hand, if the employees are not supervisors, they must be free to engage in such activities. The result is that without litigation, the employer acts at his peril and opens himself up to unfair labor practices and valid objections to the election if he answers the question wrong. Such an issue is not rendered moot by the election results, as the board theorizes. Litigating supervisory status usually does not result in any delay in the hearing. In my 50 years of experience, I can count on one hand the number of times a hearing has gone into the second day because of the litigation of a supervisory issue. All hearings last at least one day, regardless of how much the board restricts the litigation of issues. The proposed rule results in a significant increase in the number of challenge ballots, which would cause confusion among employees with the result of interfering with their right to make informed judgments. Knowing your ballot is going to be challenged will also discourage some employees from not voting. It is a form of intimidation for some groups of employees. Finally, as raised by former member Hayes at the board open meeting in 2011, if the board does not create a record of the dispute in a hearing and then exercises its newly expanded discretion to deny post-election review, there will be virtually no record for the board and the Court of Appeals to consider in a subsequent technical 8A5 case. In such cases, it virtually guarantees that the issues will be returned to the region for fact-finding.
Questions?
At what point, hi, thank you. At what point in the process do you think it would be appropriate for the determination to be made on the supervisory issue?
I think the most appropriate time for the determination to be made is at the regional director's decision and direction of election. The regional director, as I understand it, has the discretion not to make the decision. Under current standards, you have a substantive hearing on the issue, and then it's within the discretion of the regional director as to whether he will decide that in the decision and direction of election. My experience has been that in most instances, the regional director does make a finding, but it remains in his discretion. But even if he doesn't, at least management is in a situation where the issue has been litigated and both parties have stated their position and put on their evidence. So at least at that point, even though the regional director does not make the decision, at least the lawyer can step back and look at the record and then express an opinion, which lawyers do on many, many things. So whether the regional director acts to make the decision on eligibility at least creates the record, which I think is important.
So there is part of the election process during which there would be no determination.
I'm sorry?
There is a part of the election process during which there is still no determination regarding supervisory status.
Yes.
Yeah.
But even given that window, is it helpful to know whether an individual is a supervisor or not?
Well, I mean, it puts the employer in such a difficult position if he doesn't know, because the rights of that employee are going to be either legal or illegal, depending on what the judgment of the employer is in relation to what the ultimate decision is.
Oh, I have a question on, of course, hearing officers are prohibited under our statute from making recommendations. At what point do you see a decision on whether something is a genuine dispute of fact or not becoming such a recommendation?
I'm sorry, I'm not sure I followed that.
Sure. Well, under the proposal, there is the power for a hearing officer to decide whether or not something is a genuine dispute of fact and gets to go to a hearing, right?
Yes.
Right. At what point is that power to essentially control the record going to be a recommendation, or is it at any point going to be a recommendation that a hearing officer would be prohibited from making?
Well, the hearing officer under the statute has no authority to make those decisions.
Right, but at some point, what I understood from your comments was there's at some point that once the hearing officer in control of the record decides not to take evidence on something, no record is going to be created.
Right.
So there'll be nothing for us to review.
True.
From what I understood from your position on 9C1 was that started to amount to a recommendation that was prohibited under the statute, the recommendation as to whether we get any evidence or not.
Right.
Or do I misunderstand your position? It's okay. I mean, it's fine. I can basically ask someone else, but I do. At what point, what effect do you think this is going to have on courts of appeal looking at basically technical 8A5 cases?
Well, I think what they're going to have to do is send the record back for further hearings, because they're not going to have the record they need.
Okay.
Yeah, Mr. Deakins, I just have one question. Because you talked about the employer acting at its peril, and I'd like to, just for purposes of this question, disregard that. I'd like to focus the impact on the employees. You know, they're talking on these eligibility supervisory issues. There are kind of two versions. One is the employer ends up treating someone as a supervisor during the campaign. It turns out they were a unit employee. Or alternatively, if it turns out that somebody believes they're a unit employee and they interact with other unit employees in a way, turns out they're a supervisor. In both of those instances where people get it wrong, not just the employer, what's the impact on the election when the election gives effect to what the employee's sentiments are at the end of the campaign?
Well, a typical example in my mind would be that if you look at an industrial establishment setting and you've got some category called lead persons, those will typically be people that the other employees in the bargaining unit would look with favor on. They would be in some leadership role, whether they're technically supervisors or not. If those rank and file employees think that that person is going to be a part of the unit, then they're thinking, gosh, this is the guy I really have a respect for, and he's going to be in the bargaining unit, so we're going to have a strong bargaining unit. So I'd be more in favor of a union if the lead person is for the union and is in the unit. On the other hand, if he's not in the unit, I may look at it and say, gosh, this is really going to be a weak bargaining unit. It's going to impact other employees' attitudes as to whether that person is or is not in the unit. And they're not going to know.
Mr. Deakins, you said in your experience, it has been the rare case that litigating a supervisory issue would go beyond or go to a second day. Would that include litigation that you've experienced since the Oakwood decisions, where responsible direction and all of these other factors come into play in
Yes.
making those kind of determinations?
Yes.
And that's been your experience.
Yes, my experience has been that if you're litigating a single supervisory issue, which typically would be it on the supervisory status, because it's that mid-person between clear supervision and rank and file, typically you're talking about maybe 1 to 2 witnesses by the employer, maybe 1 or no witnesses by the union. It just doesn't take that long to litigate that question.
Hmm.
And it
if-
all gets down to a question of what are their duties and responsibilities.
And with respect to your concern about the examples that you gave about how a lead person may impact on the desires of others relative to their choice of going with a unit or not, wouldn't this 20% rule impact that determination? Because it would be exercised as the NPRM proposes in a situation where you have a relatively small percentage of the bargaining unit being placed in that category.
Well, on the supervisory question, I don't think it would hardly ever rise to the level of being 20%. So it's always going to be a fairly small percentage of the employees. So under this rule, those issues would never be resolved in the pre-election hearing. And I just think it's a very important from a very important standpoint. It's important to everybody so that they know whether that person is restricted or free to act on union activity and the impact it's going to have on other employees.
Okay. Thank you very much.